Warm greetings everyone. I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. Dear friends, the topic of our today's module is the concept of law and justice. Welcome all to today's talk. Dear students, this module will make you acquainted with the concept of law and justice, the relationship between law and justice, jurisprudential aspect of justice, similarities between law and justice, disparities in terms of application, disparity in terms of origin. Dear students, I would like to start today's talk by quoting Gloria Steinem as she said, "Law and justice are not always the same." Dear friends, law and justice have surely played a significant role as an abstract concept that have been used virtually from the beginnings of human society to our present times, based on the perspectives and changes that have followed the dynamics of our societies. Beyond the events and circumstances that previous societies had organized by defining and selecting the way of life, the right has frequently been personalized by a particular group of people or by a military division that has created justice and granted rights in certain interests. A portion of a society has been denied it, and it has frequently been distorted in scandalous ways by reflecting on the fact that men are the ones who grant these rights. However, these conversions have never lasted long, and this theory has frequently remained unrealized, reflecting that rights are natural and that people acquire them at birth and enjoy them until death. The disparities and complexity of how people interpret the law have frequently led to the conflicts and the acquisition of these essential rights. Through this module, we will draw philosophical and legal paradigms, analyzing from the retrospective way the application of law and the applicability of justice as an important mechanism of regulation of social relations. Law and justice have a common path of development, one by regulating the way of life of the people, that is by issuing norms, and the other by giving justice to the relative complexity and cohesion of the interpersonal relations. The concepts of law and justice are foundational to legal systems and societies, but they represent different ideas with distinct implications. The law refers to a system of rules and guidelines created and enforced by institutions to regulate behavior and maintain order within a society. Laws are enacted by legislative bodies, interpreted by courts, and enforced by various governmental agencies. Laws are written and codified, providing a clear and consistent framework for behavior. Laws are backed by a mechanism of enforcement, including police and judicial systems. Individuals and entities within a jurisdiction are required to adhere to the law. Laws are intended to provide predictability and stability in societal interactions. The purpose of law is to maintain social order, protect individual rights and property, resolve disputes, to guide behavior through clearly defined rules. On the other hand, justice is a broader concept that encompasses the fair and equitable treatment of individuals and the principles of moral and ethical correctness in the application of laws. It reflects the idea that laws should be applied fairly and that individuals receive their due. Justice focuses on fairness and the equitable distribution of benefits and burdens. It incorporates ethical considerations and principles of right and wrong. Justice can vary depending on cultural, historical, and societal contexts. The purpose of justice is to ensure that individuals are treated fairly and equitably, to promote ethical behavior, to uphold moral principles, to address wrongs, and to provide remedies. Ideally, laws are designed to promote justice by providing clear, fair, and ethical guidelines for behavior. In practice, there can be conflicts between law and justice. Laws may sometimes be applied in ways that seem unfair or may not reflect current ethical standards. Legal reforms and judicial interpretations often seek to align laws more closely with principles of justice. The concept of law evolves, influencing changes in laws and legal practices. Societal values, cultural norms, and historical context play a role in shaping both legal systems and notions of the justice. In a sense, while law provides the structured rules and systems for societal governance, justice embodies the underlying moral and ethical ideals that laws strive to achieve. Dear friends, moving further, now I would like to discuss about the concept of law. Law signifies a rule applied indiscriminately to all actions. It is a notional pattern of conduct to which action do or ought to conform. Law is a large body of rules and regulations based mainly on general principles of justice, fair play, and convenience, which have been worked out by governmental bodies to regulate human activities. In a broader sense, law denotes the whole process by which organized society, through governmental bodies and personnel like lawmakers, courts, tribunals, law enforcement agencies, and executive, penal, and corrective institutions, attempt to apply rules and regulations to establish and maintain peaceful and orderly relations amongst the people in the society. The idea of law as a guide to human conduct is as old as the existence of civilized society. The relevance of law to human behavior has become so intimate today that every person has his or her conception of its nature, which is influenced, of course, by his or her perspective. Not surprisingly, the search for an agreed definition of law has been an endless journey. There have been conflicting and divergent views of jurists regarding the nature, concept, basis, and functions of law. Law has been regarded as a divinely ordained rule or a tradition of the old customs or recorded wisdom of the wise men, or a philosophically discovered system of principles that express the nature of things, or as a body of ascertainment and declaration of an eternal and immutable moral code, or as a body of agreements of men, women in politically organized society, or as a reflection of divine reason, or as body of commands of the sovereign, or as a body of rules discovered by human experience, or a body of rules developed through jurist writings and judicial decisions, or as a body of rules imposed on men, women in society by the dominant class, or as a body of rules in terms of economic and social goals of the individuals. So friends, therefore, law can be defined by its nature, reason, religion, or ethics. Law can be defined by its sources like customs, precedent, and legislation. Law can be defined by its effect on the life of the society, by the method of its formal expression or authoritative application. It can be defined by the ends that it seeks to achieve. According to Salmond, law may be defined as the body of principles recognized and applied by the state in the administration of justice. Roscoe Pond states, Law is a body of principles recognized or enforced by public and regular tribunals in the administration of justice. Dear friends, now we will discuss the concept of justice. Justice is not only a prerequisite but the cornerstone upon which peace and harmony in any society are built. Ironically, an important concept like justice has no unified definition yet for any law to have any meaning. It must have as its goal the attainment of justice. This is because law is not an end in itself, but justice is. Just like most important concepts in law, justice does not have a unified definition but can be construed in several ways for different purposes. Hence, a descriptive meaning that exposes the essence of the concept is preferred. Justice has been used to connote fairness, equality, and legality synonymously and in some cases legitimacy. Thus, when the phrase "in the interest of justice" is used, it denotes fairness, rightness, and correctness. Justice is derived from the Latin word justus, which means that which is right, just, honest, appropriate, or correct. It can be inferred that justice is the legal or philosophical theory by which fairness is administered. Dear students, it is pertinent to discuss few definitions of justice. The first one is justice according to Aristotle. Aristotle regarded justice as the sovereign virtue and the major purpose of the state. According to him, in the perfect republic, justice was explained as the constant performance of each member of the state and their particular function in the state. Justice is treating equals equally and unequals unequally and in proportion to their relevant differences. The second one is justice according to the Black Laws Dictionary. As per the editor of the Black Law Dictionary, justice is the fair treatment of people, the system by which people and their causes are judged, the fair and proper administration of laws. According to this view, justice can manifest itself in a variety of ways, including distributive justice. Distributive justice concerns the fair allocation of resources and wealth. Procedural justice. This justice focuses on the fairness of the process and procedures used to make decisions. Next one is retributive justice. Retributive justice deals with the appropriate punishment or penalty for wrongdoing. Restorative justice. This justice aims to repair the harm caused by criminal behavior through reconciliation and restitution. So, justice is a broad and somehow abstract concept based on equality of rights, fairness, kindness, dignity, morals, and ethics. In a just world, we would not have discrimination, violence, abuse, poverty, slavery, and injustices in general. Therefore, all laws should be based on idea of justice and all governments should enforce national laws in a just and equal way. Unfortunately, this is not always the case and laws are often broken, non-respected and enforced in biased and partial ways. Furthermore, justice supersedes national legislation and applies to all individuals without discrimination or limitations. Dear friends, moving further, now I am going to discuss the most important part of this module, that is jurisprudential aspect of justice. Since justice is one of the main topics of study in law, many jurists and intellectuals have developed their concepts of justice. According to Friedman, everyone who rejects natural philosophy formulates the ideas of justice. The different theories of justice have been divided into two categories by Kelsen: metaphysical and rationalistic. Justice is defined scientifically or semi-scientifically in rationalistic ideas. Conversely, it is possible to characterize the definition offered by the metaphysical theories as pseudo-scientific. One could argue that Plato's idea on justice are metaphysical, while Aristotle's are rationalistic. The following is a basic summary of the various forms of justice. The first one is natural justice. Natural justice implies the ends of natural law. The purpose of natural law is to ensure that natural rights inherent in all individuals remain protected when the said purpose is achieved. It can be said that there is natural justice in society. According to Justice Sarkaria, rule of natural justice are not embodied rules, being a means to an end and not an end in themselves. It is not possible to make an exhaustive catalogue of such rules. Economic justice. Economic justice refers to the effective realization of the economic rights of an individual. It is argued that to effectively administer all the other kinds of justice, economic justice has to be necessarily ensured. Next one is political justice. In a state where all individuals have an equal right to participate in nation's political process, political justice can be said to prevail. Social justice. With the emergence and growing popularity of the idea of the welfare state, the idea of social justice has occupied a central position amongst the various kinds of justice. To ensure social justice, a state must ensure that an individual, as a member of any social group, is not subjected to any kind of discrimination or unfair treatment. Next one is legal justice. Legal justice refers to the ideal of justice that a legal system seeks to achieve through the enactment of various laws and legal rules. Justice must be backed by the law. When justice is administered within the boundaries set by law, the kinds of justice administered is known as legal justice. This kind of justice is administered by the courts of law. It is also known as justice according to law. Dear friends, moving further, now we will discuss the justice according to law. Justice according to law involves applying legal principles and procedures to ensure fairness, consistency, and impartiality within the legal systems. It reflects the commitment to upholding the rule of law and ensuring that legal processes and decisions are made based on established rules and principles. Justice according to law refers to the principle that justice is administered through and by the established legal system. This concept emphasizes the legal justice is achieved when laws are applied fairly, consistently, and impartially within the framework of the legal system. This aspect involves fair procedures and processes in the administration of justice. It includes the right to a fair trial, opportunity to be heard, and the impartiality of judges. This also refers to a fairness of the laws themselves. Laws should be just and reasonable, avoiding arbitrary or discriminatory provisions. Dear friends, justice according to law demands that laws are applied consistently to all individuals. Similar cases should be treated similarly to ensure that no one is unjustly favored or discriminated against. Consistent application of laws provides predictability and stability, which are essential for maintaining trust in the legal system. In this part of the module, we will discuss similarities and disparities between law and justice. So friends, what are the similarities between law and justice? The concepts of law and justice are fairly similar, as most laws are thought to be just and fair. Some of the main similarities between the two include: both concepts regulate human behavior and aim at creating a more just and equal environment. Law should be based on the idea of justice and should be implemented and interpreted in just a manner without discrimination. And both are based on the ideas of morality, equality, order, and fairness. Moving further, the next is the distinction between law and justice. Although the two concepts are strictly linked, there are key differences that cannot be overlooked. The term law refers to an existing and concrete set of written regulations established by the government to regulate and control the actions of the citizens. Conversely, justice is not a universally recognized concept and is subject to interpretations. Justice is often depicted as a woman wearing a blindfold, representing equality and fairness, and applying laws and regulations to all individuals without discriminations. Yet, there is no common understanding of justice and there is no unique book or text to refer. Laws can vary from country to country, and the process with which they are created can change as well. For instance, in democratic countries, laws are adopted following a long debate and an even longer process of checks and balances. Conversely, in authoritarian countries, laws are decided and established by the ruling party or by the ruling person, without seeking the support of the majority. On the other hand, the idea of justice is more or less consistent across all countries. Moral values and ethics tend to supersede borders and geographical divisions. Dear friends, it is important to know about disparity in terms of application. Laws apply within one country and to all individuals under the government's jurisdiction. Furthermore, international law applies to all countries that ratify certain covenants or treaties. National laws are enforced by the government and its bodies like police, judiciary, etc., while international law is enforced by international organizations and tribunals. On the other hand, justice is the underlying principle upon which all laws should be based. Yet there is no implementation of justice as such. But laws and norms can be implemented and enforced in just and fair way by judges, governments, lawyers, and international bodies. Moving further, disparity in terms of origin. Laws are created by politicians through a long process of checks and balances and can be approved or not by the country's population. The creation of law follows a different process depending on the country and can last a few days or even months, whereas justice is not created. It is a broad concept that unites universal, ethical, and moral standards. Although it is not universally recognized, the idea of justice is based on values and principles that are intrinsic to human nature. Dear friends, at the last but not the least, the origin of administration of justice. It is the social nature of men that inspires them to live in a community. This social nature of man demands that they must reside in a society. However, living in a society leads to a conflict of interest and gives rise to the need for the administration of justice. This is considered to be the historical basis for the growth of the administration of justice. Once the need for the administration of justice was recognized, the state came into being. Initially, the so-called state was not strong enough to regulate crime and impart punishment to the criminals. During that point in time, the law was one of private vengeances and self-help. In the next phase of the development of the administration of justice, the state came into full-fledged existence. With the growth in the power of the state began to act like judge to assess liability and impose penalties on individuals. The concept of public inquiry and punishment became a reality. Thus, the modern administration of justice is a natural corollary to the growth in the power of the political state. Dear learners, I would like to end today's talk by saying that relationship between law and justice is quite intimate and complex. Justice is a term that is capable of multiple interpretations and definitions. It is incapable of being confined within a definite scope. Thus, a legal system shall only administer justice according to its understanding of the term. In conclusion, it can be stated that justice according to law and not justice is the end goal of the law. The relationship between law and justice involves a dynamic interplay where the law serves as the formal structure for administering justice, while justice represents the moral and ethical goals that laws strive to achieve, while laws provide the framework for legal proceedings and resolutions. Justice serves as the guiding principle that ensures those laws promote fairness, equality, and ethical behavior. Continuous efforts in legal reform, judicial interpretation, and ensuring access to justice are essential for aligning the legal systems with the principles of justice. The relationship between law and justice is both complex and interdependent. While they are distinct concepts, they are deeply connected and influence each other in various ways. So friends, with this we will end today's talk. Thank you so much. We'll see you in the next video.